Hi, I'm Ryan with the R&R Law Group, and today we're going to start out by saying congrats to Lawrence Koplow and Kelly Flood. Looks like those were the two attorneys on the case Diaz v. Van Wee. This was an excellent case that got taken all the way to the Supreme Court of Arizona, in which Lawrence fought against the medical draw exception in a case that he had. So as you can see right there, the case number's in there. And you can see that it says jurisdiction accepted, relief granted. So first and foremost, congrats, LK. That's a huge win. I know that you put a lot of work into this. Probably one of the brightest legal minds that the defense community has done some excellent work with DUIs. We learned from him through many CLEs and a lot of other things. So great work on this. Today we're just going to discuss kind of what that means. So what Diaz v. Van Wee went into was the medical draw exception in DUI cases. So here you see we've got the statute 281388. It says that in DUI cases that notwithstanding any other law, if law enforcement officer has probable cause to believe that a person has violated 28-1381 or DUI statute, and a sample of blood, urine, or other bodily substance is taken from that person for any reason, a portion of that sample sufficient for analysis shall be provided to the law enforcement if requested by law enforcement. So what that means before this case came out was basically that if you got into a car accident or for some reason you were taken to the hospital and your blood was drawn by medical staff. So again, this has to be the medical staff, so we're talking about a Fourth Amendment issue. So if the government is the one that is drawing the blood, then they have to have the probable cause, the reason to search or make that intrusion into your body to draw the blood. But you don't have that right or that constitutional argument if that is done by a private actor, meaning that they're drawing it for a medical purpose. So if you get into an accident or for some reason you're taken to the hospital and the hospital deems that in order to treat you, they need to draw your blood, a police officer could request a portion of that sample be set aside for testing for DUI purposes. So that was the way that it was up until this case came out. What happened here is now the courts went into the analysis and said, as we look at this case, should the officer be required to get a warrant before they're able to obtain that blood sample? And here they finally said, yes, it is. It was a big win for the defense community. The officer has to get a warrant before they're able to take that blood sample. So what happened is the state argued that there's a destruction of evidence or the potential for that to be destroyed. Those are the exigent circumstances that happen. So that's what they used to say in these cases before they would have that medical draw exception. That was the exigent circumstances. That the alcohol could dissipate in the blood, or that they could be given other drugs for treatment in the hospital that could cause contamination. Some of those things, those were the exigent circumstances. But here the court says no, you've already got the blood into a vial, so there's no risk for that vial to be destroyed unless the hospital catches fire and burns down, or the nurse is going to take it and say, no, there's no way you can have this. We are going to destroy all of these blood samples. Outside of something like that, this court is saying there's not exigent circumstances in order to just take those blood samples. You have to then go get a warrant now. So what happened in this case then is because the officer did not get a warrant, the court deemed that the results from the blood were suppressed, and therefore without the blood results, the underlying case likely will get dismissed or will get substantially reduced. There will be a lot of other things that can happen in order for this. So that's why this was such a big win, because it can literally touch thousands of cases in which the officers will just say, well, just give me that blood sample there. That's what we want. And that's what was happening before is any doctor would draw the blood, the officers would just take that, and they didn't have to articulate the reasons why they believed that they needed the blood, or they believed that there was a DUI underlying the offense, and now they're required to do so in obtaining that search warrant. So this just came out a little over a week ago. I know I've already seen some of the emails going back and forth. You know, it's already starting to affect cases. So again, this is a very big win for the defense community. Congrats, Lawrence. You know, again, I know that you work tirelessly on these cases, and you know, this is what happens. This is when you get someone like Lawrence to be able to help out on a case like this, to do this case. I mean, that's, you know, it's an amazing result. So if you are involved with a case that's got a DUI and there was a medical draw without a warrant, and your lawyer's not talking to you about this case, then you need to be talking to them about this case. This is something that's important. This will affect your case. This will affect any case, you know, that already has taken place or that is coming up in the future. So this is an important issue, and it's a great win for the defense in holding the government accountable to go and obtain that warrant.